Hello, everyone. So we are now back for the final part of this Harco docket. Then will be us all caught up with the Harco docket for now. I will then search around. I'll see what else is outstanding. I'll check out the New York Times docket, the estate of Travis Flores docket. We're obviously waiting for stuff still from we've got Popcorn Planet have filed their notice of appeal. Jed Wallace has filed a notice of appeal. Yeah, there's quite a bit going on. In the Lively, we have got on the 5th of January, so that's next Monday, Lively and her multiple third parties are due to file all their reasons, a motion to omnibus brief motion to keep documents sealed because they don't want us to see them. Wayfarer will get to respond on the 12th, by the 12th of January. We also have the hearing on the 22nd. Judge Lyman will be having it'll be an in-court hearing. So it's not a phone call that we can dial into. It will be, in person at the court. On the 22nd of January, I believe Lauren is going to try and get there. I don't know about anyone else, but I've spoken to Lauren and I know she is, looking to see if she can get there. So I'll keep people updated on that, as I'm sure she will herself. That hearing will be to deal with the motion for judgment on the pleadings, motion for summary judgment, the spoliation sanctions. It's probably a good few things, a good few issues they're going to try and deal with in one hit. So I'm anticipating that it is going to be incredibly hard for Lively and her, gaggle of friends in high places to keep their crap sealed for much longer because, I'm famous is not going to cut it as an excuse. Judge Lyman has already said that he's incredibly strict when it comes to public right of access, whether you like him or not. When it comes to public access, he is, a stickler for, the First Amendment trumps anything else. So there was obviously very narrow exemptions to keep things permanently sealed or redacted. And that would be things like, medical records and trade secrets, etc. But other than that, and a few other exemptions, everything gets unsealed. And I think it's going to be incredibly hard for Lively or WME, Sony, etc., all the third parties who are going to request continued sealing. It is going to be incredibly hard for them to defeat the First Amendment and the public right of access. So I anticipate a lot of stuff suddenly getting unsealed in one go, which so I'm trying to catch up with all of these side lawsuits now in anticipation of that. This is the final thing on Harco. So let's go. This is Wayfarer's response. So again, Harco filed a supplemental reply, a sur-reply, to what was a fully briefed motion to dismiss or stay from Wayfarer. Wayfarer are opposing that request for a sur-reply. So here is a letter of opposition. Dear Judge Lyman, because obviously he is the same judge on the Harco, on the Harco docket he is, as he is the Lively docket. Defendants submit this letter in opposition to Plaintiff Harco's improper motion seeking leave to file a sur-reply in further response to the defendant's motion to dismiss or stay, while simultaneously submitting the sur-reply before obtaining the leave it seeks. As a threshold matter, your individual Rule 1C, which Harco cites, explicitly states that letter motions may be filed when permitted by the SDNY local rules and the SDNY electronic case filing rules and instructions. Neither the local rules nor the electronic filing rules and instructions permit filing letter motions seeking leave to file a sur-reply, and Harco does not refer to any such rule or other authority permitting it to file its improper letter motion. In fact, Local Civil Rule 6.1, which governs service and filing of motion papers, provides for a motion, an opposition, and a reply. It does not mention a sur-reply, nor does any other local rule. Moreover, it is improper to submit a sur-reply while simultaneously asking the court for permission to file it, as Harco does here. Harco's premature sur-reply violates both the letter and the spirit of the rules designed to prevent unauthorized motion practice by simultaneous filings. Furthermore, Harco's letter motion fails to identify a single new argument or issue defendants raised in their reply that is not responsive to the arguments Harco raised in its opposition brief. Each of the new cases that defendants cited in their reply was responsive to an argument Harco made, and Harco does not claim otherwise. Nor did Harco's counsel contest this fact when defendants' counsel made the same point on December 22, 2025, in response to an email we sent regarding Harco's plan to file this request, which omitted Harco's intention to simultaneously file a sur-reply along with the request. Accordingly, Harco's improper sur-reply filing should be struck by this court. Okay, so they're asking for the sur-reply from Harco to be struck. In the event this court does not strike Harco's improper sur-reply, Harco's attempt to distinguish defendants' cited cases fails. First, Harco states that 7 of the newly cited cases do not support the argument that the state court action need not involve the exact same parties and issues. However, most of the cases that Harco addresses were not cited for that proposition. Okay. XL Insurance America, Inc. supports that the declaratory judgment doctrine is couched in the permissive language of the Declaratory Judgment Act and is aimed at preventing district courts from indulging in gratuitous interference. Managing Director's long-term incentive plan confirms the rule that court must look at litigation holistically in determining whether proceedings are parallel. De Cisneros and Muchantaf, I hope I'm saying that right, rebut Harco's incorrect assertion that the Colorado River Doctrine only applies in actions involving federal policy or a unified state system. De Cisneros also supports the principle that the Brillhart-Wilton Doctrine seeks to avoid inconsistent and mutually contradictory determinations. Radioactive JV rebuts Harco's use of the case law that demonstrated use of the first to file rule. All of these cases support the propositions for which they are cited, and nothing in Harco's inappropriate sur-reply renders the rules articulated in these cases inapplicable here. There's a little footnote, actually, which I will read because I think it's relevant. Additionally, even if the notice prejudice rule does not apply here, as Harco contends in response to Pitzer College, that does not take away from California's strong interest in protecting California-based insureds and in ensuring insurance laws and regulations are followed. In Gustavia Home, while both parties may have briefly appeared in the state case, the actual parties in the state and federal actions at issue differed. Accordingly, Gustavia supports defendants' request for abstention here. Defendants cited to Mashat to support the proposition that even if the claims asserted are not identical, if the claims raised in the federal proceeding could be satisfactorily adjudicated in the state proceeding, abstention may be warranted. Despite the fact that the claims the relief sought and the involved parties were not identical, the court found abstention was proper. While the claims differed, as they do here, the outcome sought was the same. Similarly, Catlin Insurance supports the proposition that there is no requirement under Wilton abstention that each party to the federal case also be a party to the state case. In Catlin, the court emphasized that the query is whether the scope of the related proceeding is equivalent, whether the claims of the parties to the declaratory judgment action can be satisfactorily adjudicated in that action, and whether such parties are amenable to process in that proceeding. It is likely that both courts in the present action would need to interpret similar, and in some cases nearly identical, insurance policy provisions. In Catlin, as here, the court determined that because the state court would need to answer some of the same questions as the federal court, and because those questions were purely of state law, abstention should be granted. As in this instant action, the Catlin court came to this conclusion, even though Catlin was not a party to both actions. Stonecore Group likewise supports the proposition that parallel proceedings are not required for abstention, and it is sufficient that the factual and legal issues in both cases overlap significantly. In Stonecore, as in the current action, all necessary parties had yet to be joined. Despite this, the court found that given overlapping issues of fact in both the federal and state actions, abstention was proper. Further, Harco ignores this court's reminder in Stonecore that Wilton explicitly declined to delineate the outer boundaries of court discretion, and that Wilton's holding was premised on the notion that a federal court should refrain from issuing declaratory judgments on issues that can be better settled in the proceeding pending in state court, which can be true even when the state court action is not a parallel proceeding. Finally, Harco claims Dalzell management and Dittmer reject abstention for many of the same reasons present here. This is incorrect. While defendants cited these cases to support more general principles present in both the Brillhart-Wilton and Colorado River analysis, those cases involved application of the Colorado River doctrine, which is not applicable here. Thus, Harco cannot distinguish those cases based on their facts, as they are not afforded the same discretion as cases like this one that is decided under Brillhart-Wilton. For these reasons, Harco's procedurally improper and substantively baseless sur-reply should be disregarded by this court. Okay, that's brilliant. I love it. I think they've done that really, really well. I like that they've asked for the sur-reply to be struck, and then kind of said, you know what, if you're not going to strike it, here's our response. And the response just, dismantles what Harco says. So really, really good reply. I guess we're just going to wait and see what Judge Lyman says. There's not much else we can do about it. But yeah, I mean, individually, both sides are presenting good arguments, but when you put them all together, Wayfarer side is coming out stronger for me. And this has got nothing to do with, I support Wayfarer in the Lively case. I support Wayfarer in the Lively case because there's no evidence of Lively's claims. And actually, there's evidence that she's not telling the truth. That does not mean I blanket support Wayfarer. If Harco had the stronger case, I would be supporting Harco. But just looking at these filings alone, Wayfarer is doing a better job of their legal arguments, in my opinion. All right, guys, that's it from me. Have a good evening.